Are we on?
Yes.
All right. Hi, everyone. Welcome to the session on the Data Protection Bill. Today, we want to discuss the impact of the Data Protection Bill on businesses in India, especially startups. Before starting off, I would like to introduce myself and the team with me. My name is Deepro Guha, and I work at the Quantum Hub. We're a public policy and advocacy firm based out of New Delhi. I have with me Abhinav Saikia and Nikhil, who are my colleagues and will help me present this deck. The idea behind this presentation is basically to study the impact of the data protection bill on Indian startups. And we are doing this in consultation with the Alliance of Digital India Foundation, which is ADIF. Now, onto the deck in itself. The idea today is to sort of discuss what the various impacts of the data protection bill will be on Indian startups, and come up with sort of learnings that we can go forward and use in representations to either the government or parliament while they are considering the amendments to the data protection bill. So during the presentation in itself, I want to keep it conversational. I will open up after every couple of slides to questions or inputs from your side. Whoever wants to, has anything to add to what we've covered in those slides before is welcome to. And through this, we want to sort of develop an understanding of how Indian startups are looking at the data protection bill. All right. Nikhil, can we start the presentation? So just to give a background of the data protection bill, the initial thoughts behind the data protection bill really started from 2017, when the Supreme Court ruled that under Article 21 and right to life, right to privacy is also a right by our constitution. And under this right to privacy, for the first time, informational privacy was recognized as a right, which means information about the self is and protection of that information is a right. So that's where the sort of protection of data rights, the thinking behind the protection of data rights comes about. Following that decision of the Supreme Court, the government set up the Sri Krishna Committee to look at how data should be handled and how data rights should be protected, given the proliferation of social media and data all around that, government initiatives like Aadhaar and GST. There was a lot of creation of a lot of data, and the government wanted to know how to regulate such data. So the Sri Krishna Committee gave its report and drafted a bill for the government for data protection, which was eventually became the Personal Data Protection Bill, which was based on Justice Sri Krishna's bill. Once the Personal Data Protection Bill was introduced in Parliament in 2019, it was sent to a joint parliamentary committee who studied it for about 2 years, and finally in 2020, at the end of 2021, gave a report on it. This report asked for substantial changes on the bill, and these changes are now being considered by the Ministry of Electronics. One of the main changes, of course, was the fact that it wanted to cover personal data as well as non-personal data, and therefore the change in the name of the bill, which now is called the Data Protection Bill. So the current status of this bill is that MeitY is considering the changes, and after sort of finalizing the changes, it's going to go in front of cabinet and eventually then again be introduced in Parliament in the form of the Data Protection Bill. It's likely that this bill may be introduced either in the budget session or the monsoon session of this year. That's where we are at currently, just to give you a sort of a background on the Data Protection Bill. Next slide, please, Nathan. Right. So in terms of the purpose of the bill, why the government came out with this bill, there are three major reasons. Firstly, of course, as I mentioned earlier, there's so much data being created, so much personal data. There was a need for privacy norms when it comes to these data and rights to be sort of crystallized with respect to this data. So digital privacy of individuals was one reason. The other reason was, of course, promotion of the digital economy. Today, a digital economy is one of the fastest growing sectors And the government does recognize this. And they felt that regulation of data is one of the key components of regulation of promotion of the digital economy. And lastly, of course, the interest and security of the state, given the proliferation of cyber crimes, etc., a secure and a robust framework to sort of protect the state from cyber crimes and things like that was also required, which would be done through this data protection bill. So that was sort of the overall view of the government before coming up with this bill. Now, before going into the nitty-gritties of the bill in itself, I wanted to discuss some of the key aspects of this bill. So first and foremost, the application of this bill. This bill applies to any data being collected, stored, or processed within the territory of India, first and foremost. Also, it would apply to entities registered outside India if they're handling any of this data which is stored in India. There's also a provision which requires the data protection bill to apply if there's profiling of an Indian individual involved in the processing of data. Therefore, there is some amount of extraterritoriality in this bill. This is pretty similar to GDPR. When GDPR was passed in the EU, they also had similar provisions which required businesses outside the EU, which cater to EU citizens also outside the EU, to follow GDPR. So application is pretty broad, and not only is it applicable to data in India, but also to entities outside who are sort of serving a business purpose in India or who are dealing with data of Indian citizens. Now, when it comes to personal data, the definition is very, very broad. It says that personal data is information by which any natural person can be identified. So both GDPR and our data protection bill treat personal data in a pretty broad way. One difference that our bill, of course, has with respect to GDPR is that it doesn't recognize pseudonymized data. Pseudonymized data essentially is data which has been masked. The personal element of it has been masked, and the natural person can't be identified from that data. However, because GDPR does recognize this, there is some sort of acknowledgement of re-identification of anonymized data, because if you're recognizing pseudonymized data as personal data, that means you're acknowledging that there is a risk of this data being re-identified back to its personal data. So because our definition of personal data does not contain pseudonymized data, there is sort of a lack of acceptance of the dangers of re-identification of anonymized data. As I mentioned below, now our data protection bill also includes regulation of non-personal data. Non-personal data has been defined in a very broad manner. Anything which is anything other than personal data. However, even though non-personal data has been included in this bill, there aren't that many direct provisions that are dealing with non-personal data. Most of the regulations in and around non-personal data will probably come from regulations prescribed by the Data Protection Authority, which is sort of the regulator set up by this bill. Can move on. Right. So the other major players in this data protection bill, of course, first is the data principal, the creator, the personal data who it belongs to. And then there's the data fiduciary, who sort of collects this personal data and decides how it shall be processed. That's the definition of data fiduciary. So in the cases of startups, they are likely to be defined under data fiduciary because offering any business services, you will have to collect some sort of data on the person's or personal data on the person, and therefore come under the definition of data fiduciary. Now, the data protection bill sets up multiple obligations for data fiduciaries. Some for data fiduciaries, some for a special sort of class called significant data fiduciaries, which I will come to right after this. The basic obligations for data fiduciaries include having a privacy policy, which includes, what kind of data it will process, how it will process it, what kind of consent notice it will give. Then it should have a security safeguards and a security policy, which includes details of encryption, how data breaches will be dealt with, etc. Data fiduciaries also require to have a robust grievance redressal mechanism and a mechanism to report data breaches. These are the sort of broad uh, obligations for data fiduciaries. Now, as I was mentioning earlier, there's also a class called significant data fiduciaries, and these are sort of important data fiduciaries that the government are going to recognize basis the amount of data they are processing, the sensitive data, the sensitivity of the data they are processing, the risks of harm with respect to their processing, risk of harm to data principals. Even social media platforms who have a user count beyond a certain threshold may come under such significant data fiduciaries. Essentially, this class has been created to sort of put extra obligations on companies who are handling a significant amount of data, or handling very, very sensitive data, or social media platforms, etc. The extra obligations that these significant data fiduciaries have to meet are mainly threefold. So first and foremost, they have to have a data protection officer in place who's one entity in the company who will be looking at all data related compliances. That's one. Secondly, in terms of audits, it will need to do regular audits of its data processes, so its privacy policy, security safeguards, all of that, consent notices, how it's being sent out, how data is being collected and processed. All of this will need to be audited by specific entities who are responsible for such auditing. And lastly, significant data fiduciaries will also need to take up data protection impact assessments. These are basically impact assessment of any new technology, any new way of profiling that the significant data fiduciary comes up with. Again, all of this will require some additional compliance, additional regulatory costs, and will lead to, sometimes may lead to onerous burdens for either the data fiduciary or significant data fiduciary, depending which one it is. Nikhil, if you can move on. So out of these obligations, there were a couple that stood out for me, and I wanted sort of your opinion on it also. One of the transparency obligations on data fiduciaries is that they have to disclose their processing methods and algorithms. This has been added to the data protection bill by the Joint Parliamentary Committee recently. And it basically asks that a data fiduciary should let the DPA check the fairness of algorithms and methods used for processing of personal data. Now, this brings up quite a few legal questions. For example, any company that is using an algorithm may be using that algorithm as a as a trade secret, may not want to share that. Secondly, there's also international legal obligations. There are multiple foreign companies that have invested in India who might be having proprietary data analysis methods, which may not necessarily want to share with any third party. So any disclosure of algorithms or processing methods, as the bill is currently asked for, may prove to be troublesome for company startups in India, as well as foreign investments who've come into India from outside. Another obligation that has been put, and this time this obligation is on the Data Protection Authority and not on data fiduciaries, is that integrity and trustworthiness of hardware and software would have to be checked by the Data Protection Authority. Now, the thinking behind this is, recently with proliferation of IoT devices and things like that, there's also a chance of leak of personal data from hardware. So the JPC has suggested that there should be some set standards of hardware, and the DPS should be responsible for testing and certification of such hardware. Now, the issue with such a clause is that there are already multiple standards that currently exist. For example, there's MeitY has a standards for electronic goods. For telecom goods, there's the wireless planning committee of the Department of Telecom that sort of certifies all products. So having multiple of these certification requirements may just add to business costs, regulatory costs, and also red tapeism. So those are sort of two major issues that may be faced once the obligations on data fiduciaries is operationalized. Before I move on to NPD, I just wanted to see if there are any questions that have sort of come in. Nikhil, are there any questions on?
There are no questions.
No question. All right. Right. Then moving on with the inclusion of non-personal data in the bill. As I mentioned before, that the JPC has suggested that non-personal data be included in the PDP bill, and therefore calling it the data protection bill. The logic employed by the JPC is that it's very difficult to distinguish between personal data and non-personal data in the way data is collected today. A lot of it is mixed data sets. A lot of it is not completely distinguished. So in cases like this, it would be better to have one singular regulatory body looking over both non-personal data and personal data. So that is the logic behind including non-personal data in the bill. Now, in terms of the actual provisions of the bill, there are two places where non-personal data is mentioned. One is clause 25, where it gives the DPA the power to sort of set a procedure if there has been a non-personal data breach. And secondly, in clause 92, where there's sort of a data sharing mandate, wherein the bill is basically saying that the government can ask for sharing of non-personal data from data fiduciaries as well as data processors, if it's for improvement of government services. So both reporting of non-personal data breach hasn't been detailed out. The DPA is likely to come out with regulations on it. The potential data sharing mandate has created some concern within industry. This is because it's widely worded, and it could lead to a lot of problematic situations for industry, in the sense that if the government is if the government is given the power to ask for any data from industry, that opens up issues of intellectual property rights, trade secrets, proprietary details that companies may not want to share. So on this front, there is the chance of DPA coming up with more certain regulations, so that the data sharing mandate is clearer and the government and industry knows within what boundaries the government can ask for data sharing. This would also provide some amount of options for advocacy going forward, because the industry would probably engage with the government going forward on the data sharing mandate, because this is a point of major concern. In terms of other open questions with respect to non-personal data, which haven't been spelled out by the data protection bill till now, firstly is in terms of transparency and accountability mechanisms that are followed by data fiduciaries. Now, for personal data, the data protection bill asks for certain compliances in terms of transparency accountability measures. For non-personal data, this hasn't been spelled out exactly. Similarly, for mechanism of governance rights of non-personal data, who owns non-personal data? Because it's not personal data, you can't say that one person owns non-personal data. So whether it be community rights or how these rights are enforced, who has the power to enforce these rights, these things have also not been spelled out. And going forward, we would expect either the government through rules or the DPA through regulations to spell out some of these, to sort of remove some of the confusion that is currently going around with respect to how non-personal data will be treated under the bill. Then moving on to consent, and I would think this is sort of the main meat of the data protection bill, especially when it comes to startups, because the startups will have to decide how to get consent for processing of data within the boundaries that the bill sort of proposes. So what the bill proposes is any sort of personal data processing needs to be consented to. This consent needs to be contain certain elements. For example, a startup today trying to collect personal data will have to send a consent notice to the data principal. This consent notice will have to contain why they are processing the data, what kind of data is being processed, how it is being processed, if there's any cross-border transfers involved, if this data is being sent outside India to be processed. All of these details will be needed to told to the data principal in the form of a consent notice. And then after reading that consent notice, the data principal will have to give the consent, which will be required to be free, so without any undue influence, informed. So it will need to be, the person will need to know what they are consenting to, and it needs to be specific and clear. Means the consent can't be vague and can't be too broad. It needs to be for one particular sort of purpose. And the data principal will be needed to give the right of withdrawing the consent. So these are the broad principles within which consent will have to be got from a data principal by the data fiduciary. Now, in terms of impact of startups uh, for consent, we have seen that GDPR follows a similar sort of mechanism. And what studies show in GDPR is sort of a consent fatigue, which means every website that a data principal is going to is having to consent on that same sort of notice, and there's a fatigue. So the learnings in Europe at least is that there might be services that bundle these consent mechanisms that are coming up that might get popular. The other learning from Europe is that with respect to cookies, because that is basically the main sort of data collection that a lot of startups would do. Uh, yeah, in terms of cookies. So what kind of data can be collected by cookies? That will be the main issue when it comes to startups in India, that they will have to draft their notices basis that. And this would, of course, involve some cost, legal costs, getting a lawyer to draft these notices, making sure these notices are as per the data protection bill. Uh, these would be the relevant considerations that a startup needs to keep in mind. Yeah, you can move on, Nikhil. I think we have a question. Nikhil, could you read out the question?
Sorry, Abhinav, can I request you to read the question, please?
So the question is it possible that a data fiduciary has to conduct a data audit or a DPIA, that is the impact assessment exercise, even without being notified as a significant data fiduciary?
Yeah. So this is actually a very good question. The data protection bill also has provisions and gives the data protection authority the right to ask for a data audit or a data impact assessment, even to a normal data fiduciary who's not a significant data fiduciary. So if the data protection authority feels that it's important enough to do a data audit of a company without the company being a significant data fiduciary, that is also possible. The data protection bill provides the right for that. And I also see another question with respect to algorithms. Can we refuse to disclose our proprietary information like algorithms? Um, Again, good question, but the data protection bill does not really provide any direct way to refuse disclosure of proprietary information like algorithms. I think this would have to be a sort of conversation between industry and the government on what kind of algorithms and how need to be disclosed, how these algorithms need to be disclosed. Of course, all sorts of algorithms cannot be disclosed wholesale because they will include proprietary information. So the form of disclosure, I think, will become important going forward. And the Data Protection Authority has been tasked with this, with the responsibility of sort of deciding on what form of disclosure it is going to be. Right. Thanks for those questions. Moving on, we were just discussing consent forms before this. There are certain times when data can be processed without consent by the data fiduciary. Now, what the Data Protection Bill does is it provides a sort of wide ambit for this when data can be processed without consent. It says it can be done when there are reasonable purposes for such processing without consent. And these reasonable purposes will be decided by the Data Protection Authority, again, basis certain elements. For example, how practical it is to obtain the consent. There might be times when, obtaining the consent may not be practical, may not be advisable also in the case of, say, whistleblowing. What is the public interest involved in processing the data without consent? What is the effect on the data principal's rights? If there is a negligible effect on the data principal's rights, and then there's a need to process the data, then in those situations, maybe there's the reasonable purpose met. And of course, finally, the legitimate interest of the data fiduciary itself. Maybe the data fiduciary has contractual obligations to process data, and obtaining consent at that point is difficult. So in cases like that, the Data Protection Bill does give a little bit of leeway in terms of processing data without consent. It also lays out certain individual circumstances where data can be processed without consent. For example, as stated here, prevention of unlawful activities, mergers and acquisitions, credit scoring, whistleblowing, etc. There's a larger list provided in the bill, and the Data Protection Authority has also been given the charge of adding to this list if need be. And finally, there is, of course, also room for advocacy on this front, because the reasonable purpose has not been clearly defined. It's been left up to the Data Protection Authority to say what exactly reasonable purposes will be. So again, this is a chance for industry to sort of talk to government and figure out what are the sort of situations where data should be allowed to be processed without consent. We can move on. Right. Now, the Data Protection Bill also recognizes that there are certain special conditions that need to be kept when it comes to processing of children's data. So there are two main sort of conditions that have been kept. Firstly, a proper age verification mechanism. It puts the onus on the data fiduciary to figure out if the data principal is a child or not. Of course, children here is defined as anyone below 18 years. And secondly, if the data principal is a child, then there's a parental or guardian consent that will be required for the data principal to use the services of the data fiduciary. So these are the two major obligations that are put on data fiduciaries when it comes to children's data. And when children are using services, there are certain things data fiduciaries can't do. For example, profiling the children, tracking the activity, targeting ads at the children, as well as any other processing that can possibly bring significant harm to the child. Again, this any other processing point is very wide, and a lot of things can be placed under the ambit of this. So it remains to be seen what the any other processing bit is recognized as. Right. Nikhil, would you want to go into a little more detail on what are the sort of implications for startups when it comes to children's data?
Sure. Thanks, Deepro. There's one, the JPC has now recommended that they are not willing to change the age of who's considered as a child. So a lot of industry bodies said that it's not necessary that anyone below 18 be treated the same way that someone below, say, 13 years of age be treated. And even though they've retained the same age classification, which is anyone below 18, they have now said that once the child turns 18, they should be once again given the chance to either revoke their consent or continue availing of that service by providing the consent. So this essentially means that any startup who's offering a service to a child before they turn 18 has to now obtain their consent twice. Once their parents' consent before the child turns 18, and once the child's own consent, as an adult once they turn 18. So that essentially is they've increased the burden on the startups as it is right now. So that's one key suggestion that's come from the JPC. Another point that I feel it's worth mentioning is whether there can be any kind of guidance from the government on what these age verification mechanisms can look like. So thus far, even the JPC report, it does not go into too much detail on what exactly this will look like. There has been some discussion on whether you can have any kind of video verification, where you ask the child to ask the parent to maybe record a video of the child using, or maybe some other questions that only an adult can answer, which a child cannot. But even though other jurisdictions which are slightly more mature than ours, like the USA, even within the GDPR, they have adopted some mechanisms. But what route do we take in India is something that's still unclear at this stage. So this once again will be something that we have to keenly watch the regulations that come from the DPA on this.
Thanks, Nikhil.
Over to you, Deepak. Yeah.
Thanks for that, Nikhil. I think we can move on to the next slide. Do we have any questions on children's data? No, don't. Right. Okay. So the other important element of the data protection bill, and one of the most important elements, I would say, is the data localization mandate. So the categories of data that the bill recognizes is one, personal data, any data that can identify a person. Then there's sensitive personal data, which is a special class of personal data, including things like financial data, sexual orientation, biometric data, etc. This data category has been created to give it a special kind of protection to sensitive personal data. And then there's the third type of data, which is critical personal data. This has not been defined by the government. The government shall define it going forward, notify a definition. But this sort of data has been given the highest sort of protection, and it can only be stored and processed in India. It can be sent outside in only minimal circumstances. Personal data, on the other hand, can be sent outside India as long as there's a serving copy of it in India. And sensitive personal data, in most cases, needs to be processed in the country. There are certain exceptions when there's consent from the data principal, when there's permission from either the DPA in consultation with the government, then it can be sent outside India. We'll go into these details of cross-border transfer in the coming slides. So why did the government decide for these data localization provisions? One of the major reasons is, of course, law enforcement. If you have the data in India, it's easier to enforce Indian law. Also, there's the issue about foreign surveillance, and having data in India reduces the chance of foreign surveillance. But I would say one of the major reasons for data localization was also, sort of expediting economic growth by giving a fill up to the data ecosystem in India, fostering innovation. India creates a lot of data, one of the highest amounts in the world, I would say. So keeping that data in India, using that data to innovate further and create services, ensuring there's fair competition between entities coming in from outside and entities in India. These were sort of the broad goals of the government when it came to data localization. Nikhil, next slide, please.
Deepro, there's the question on children's data. Would you like to take that?
Yeah, sure.
Yeah. So the question is, are there any best practices in what kind of age verification mechanisms we could adopt? And there is a second question that says, isn't there a risk children will be smart enough to overcome whatever age verification mechanism we implement?
Right. So to answer the second question first, there is, of course, always the danger of children being smart enough to overcome whatever age verification mechanism we come up with. But I think the idea behind this rule is such that you create the boundaries that, at least create a basic level of age gating. So children, all children can't get, access to all kinds of services. That basic level of age gating is, I think, what the data protection bill is going for. Of course, there might be individual cases where child is smart enough to overcome that. But that's not what I think the data protection bill is aiming at. And on the first question on best practices, well, as Nikhil mentioned earlier, there've been multiple sort of ways to deal with this age verification mechanisms. Some states in the US have used the credit card system where, you can only use a credit card to sort of verify your age, logic being that a child might not have access to the credit card. There have also been questions that are specific to, an adult, only an adult can answer. Some US states have also used such a mechanism. But to be fair, I don't think till now there's one foolproof way of age verification mechanisms. The data protection bill does provide for this with respect to children's data. It also does provide for it with respect to social media companies. Social media companies also, some of them, the bigger ones, need to have some sort of age verification mechanism. So it'll be interesting to see which approach India adopts. But I must say there's no best practice sort of to say that there is only one way to go about this.
Right. There's one more question on consent. So it says that given that consent framework is a complicated topic and various international bodies are still exploring various designs for it, are there any best practices for how to obtain consent? It's a loaded question.
It is indeed. So, I mean, in terms of best practices, again, we can look to the EU because they have passed the GDPR a few years before our data protection bill, and how consent framework there has worked. In terms of the elements required in a consent notice, our system seems to be very similar to the one in Europe, wherein you're asking for what kind of data is being processed, why it is being processed, also telling the data principal the rights he or she has over such data. These are the sort of basic elements that both GDPR and our data protection bill require. There are reports to suggest that this has led to increased awareness of data rights across Europe. And I would assume that a similar case would arise for India, where if you're given the information over what rights you have over your data, you're likely to use it more. So I think just a proper implementation of the current provisions would lead to increased awareness of data rights, and therefore a better sort of data economy in India. That's what I would say. Right. Any other questions before I move on, Abhinav? Okay.
Yeah.
Right. So we were just before this talking about the data localization bit from the government's perspective, why data localization would be necessary. Now, the flip side to that is there are certain concerns that industry might have when it comes to data localization. For example, increased infrastructure costs. India's infrastructure when it comes to data servers is not as developed when compared to the amount of data it creates. So there will need to be heavy investment in infrastructure increase. And in the short term, that will probably lead to increased infrastructure costs for startups and businesses alike. I think the government has also recognized this, and in the latest budget, they have included data centers as infrastructure, which would mean that borrowing costs for data centers would be lesser. And there is a clear sort of goal to go towards a broader data infrastructure in India, so that the option of storing data in India is there for startups, businesses, everyone here. So in the short term, there's likely to be increased infrastructure costs. That's one industry concern. Second industry concern would be that the access to state-of-the-art technology for Indian data fiduciaries may reduce. Now, why this would happen is you can look at it from the say example of cloud computing. A lot of startups today would probably be using AWS's cloud computing services. However, if if these data localization measures are implemented, then sending sensitive personal data to a foreign cloud server might be difficult. You would have to get individual contracts approved by the government, leading to delays in time, also probably increase in costs. Furthermore, when it comes to data to put into AI ML models, currently what the Indian companies do by sending data outside India to get it processed and sort of teach AI ML models, that the ability to do that will decrease going forward. So that's also a drawback for industry. The other major concern that comes up is, of course, trade barriers. When you're having these data localization mandates, it's likely that other countries in negotiations of, when it comes to trade treaties are likely to create an issue. For example, the US ambassador recently, was trying to convince the World Trade Organization to ban all sorts of data localization measures. So there's clearly a pushback from at least Western countries in terms of data localization. So that's something that India as a country would have to deal with going forward. And lastly, one logistical issue of the way the sensitive personal data and critical personal data have been defined. Firstly, critical personal data is still not defined. It's left up to the government. So there's confusion there. In terms of sensitive personal data, there's a whole list of things that have been included in, like I mentioned before, financial data, sexual orientation, biometric data, etc. But having broad categories like financial data under sensitive personal data may be problematic, because financial data can include one of many sorts of data. And a large number of companies would come under the head of companies collecting sensitive personal data if financial data is included under sensitive personal data. This leads to, again, this would lead to extra compliance costs for a large number of even small companies, and therefore it is an industry concern currently. Now, in terms of the actual provisions for cross-border transfer of data, for sensitive personal data to be transferred outside India for processing, there are two things that need to be done. Firstly, there's the explicit consent that is required of the data principal. And secondly, there will have to be a contract between the data fiduciary and the data processor outside India, regulating the processing of such sensitive personal data. And this contract will also have to be approved by the Data Protection Authority in consultation with the central government. Now, it is this approval that sort of creates an extra barrier, because every time an Indian entity, a business, a startup has to send data outside India, if it has to go to the Data Protection Authority, who then go to the central government for approval, that's likely to be a long drawn process. And therefore increase in timelines, again, probably increase in costs. While approving such a contract, the central government has to look at a few things. For example, if the country the data is being sent to, whether that would have adequate protection. Secondly, if such transfer of data would not hinder law enforcement. Thirdly, if the data shared ahead would not further be shared ahead with any foreign government without the approval of the Indian government. And another broad clause which says that the contract can't be against state or public policy. Now, to meet these four criteria, it's really subjective, because there are terms like adequate protection, there are terms like state or public policy. So it's likely that the government can take its time with respect to approving these sort of contracts. That's likely to increase timelines, and we'll talk about the implications of these rules in the coming slides. In terms of cross-border transfer of critical personal data, it's allowed in very minimal circumstances. One, when prompt action of health or emergency services is required. Secondly, when the government sort of specifically allows it for reasons that haven't been clearly drawn out. And in these cases where the government specifically allows it, then also adequacy requirements, as in sensitive personal data, meaning that the other country that it's being sent to should have adequate protection for such data. These will have to be met. So these are the conditions for transfer of critical personal data. It would be more difficult to get critical personal data out of the country than sensitive personal data. Now moving on to implications of cross-border transfers. As I kept mentioning, of course, there's likely to be compliance delays because you're having to deal with not one authority, but two authorities, the Data Protection Authority, as well as the central government. They will also have to decide on multiple questions which are subjective. For example, adequacy provisions, whether the other country has adequate protections for the data that is being transferred there. Now, one thing to mention here is that the GDPR, which also has similar adequacy provisions, lays out clear elements of these adequacy provisions, basis which the government can decide if the other country has adequate protection or not. A famous case in this regard was Schrems 2, wherein a EU entity was sharing data with a US government entity, and EU decided that the American entity did not have adequate protections. This was in light of the American government PRISM surveillance program. But coming back to our case in hand, deciding whether a country has adequacy provisions or not is a subjective task, and is likely to take time if it's in a case-by-case basis. If every contract between a data fiduciary here and a data processor outside will have to be approved by the government, that's a lot of work for the government. That's also a lot of delay for industry in general working. One of the solutions for this could possibly be having either a positive list or a negative list of countries who, automatically data can either be transferred to or not transferred to, as the case may be. But of course, this will depend on industry and government consultation going forward. And the third issue, as I was mentioning earlier, is the lack of definition of critical personal data, or the broad definition of sensitive personal data. These can create possible confusion, and this confusion may be detrimental going forward because of the way data is collected, mixed data sets. It's not clear what's personal, what's not personal. Over and above that, you bring in the concept of sensitive personal data, critical personal data. It would lead to some amount of confusion, which may lead to regulatory action going forward. So another concern there for industry. And then finally, one of the other important things in this bill is the exemption that it offers for processing of personal data. So one of the major talked about exemptions is, of course, the exemptions offered to the agencies, government agencies, where on national security grounds or public welfare grounds, a wide ambit has been given to exempt government agencies. And this has been criticized has faced criticism from many quarters, especially given that the Data Protection Authority anyway is already answerable to the government. The government has various powers under the Data Protection Bill. Over and above that, this power exemption power given to government agencies seems like a little bit of excessive power maybe in the hands of the government. The other problem that comes up with such exemptions is that the adequacy requirements that India has for other countries, similarly other countries may have for India may not meet them. And this may result in lack of business investments in India, or them reducing because of these adequacy provisions, because you can't transfer data into India as easily if India doesn't have adequate protection. So that's sort of one danger to flag. The other other exemptions for processing is are more related to general practicality. For example, if someone does it for personal purposes, data processing, for example, someone collects data of his relatives and just keeps their phone numbers and other relevant information in one place, that person will not have to take consent as mentioned in the bill, because there's this exemption for personal or domestic purposes. Similarly, there's an exemption for manual processing if there's no sort of automatic computer processing involved by small entities. The government is yet to decide what a small entity is, but it's likely to be something in the range of smaller, MSMEs. These are sort of the main exemptions that are given in the bill from data processing requirements. The other exemptions are for journalistic purposes. One important exemption for startups may be in the case of sandbox. So the concept of sandbox recently has really become popular, wherein services are provided in a regulated environment, which necessarily don't have to meet all the laws of the sector. So in these cases, exemption is given from the data processing requirements. And some of the exemptions have been questioned by industry, but it remains to be seen going forward what comes into the final law in terms of exemptions.
Deepu, we have a question on data localization. So Smita asks, does GDPR have a data localization mandate for personal or non-personal data? If yes, what is the evidence of impact on EU startups?
Okay, so the data localization, first of all, GDPR does not really deal with non-personal data. Non-personal data is dealt with a separate notification. And it actually, that notification encourages sharing of non-personal data across borders. In the case of the GDPR, they don't have strict data localization requirements, but they do have strict adequacy requirements. As I mentioned earlier, when data is being transferred outside the EU as per GDPR, GDPR just lays out a process. It doesn't really restrict it too much, but it does have provisions like adequacy requirements whenever it's being sent outside EU. For example, again, the case I mentioned earlier, Schrems 2, where data was being transferred to the EU, to the US, the EU studied in detail the US's data protection regime and decided that it wasn't adequate when it comes to EU data. So to answer her question, it's not strict provisions of data localization of GDPR, but they do follow the adequacy requirements strictly. Right. Okay. Can we move on? Right. Lastly, after having discussed these multiple issues with the data protection bill, one important thing to highlight would be that the JPC has asked for a sort of tiered implementation of the data protection bill. As per the JPC, you can't immediately implement the data protection bill in all its provisions, and that would be impractical to do. So it proposes this 24-month timeline, wherein first and foremost, the DPA sort of set up, the chairmen and members are appointed. Then the DPA begins its activities. It starts sort of consulting with industry and setting up the multiple regulations it has been empowered to do so. And then move on to sort of registration of data fiduciaries and get the compliances from industry in order. And this whole process is 24 months long. It also still remains to be seen in these 24 months when the DPA would start sort of pushing back on industry to start, complying with all the regulations, like folks to send consent notices, to start their data audits, to have the data protection impact assessment, et cetera. That is likely to happen somewhere in between the 9 to 24 month range if this is followed, because registration of data fiduciaries would be in 9 months. The entire bill is supposed to be operational in 24 months as per the JPC's recommendation. So between 9 and 24 would be when sort of the advocacy consultations would be going on, and the minute details of how compliance is to be done would be decided. Having said that, this is of course just a recommendation by the JPC, and it's not a non-part of the bill that they have suggested. So the government still might either increase or decrease this sort of tiered timeline. But one can expect some sort of tiered timeline when it comes to the ultimate implementation of the act. And I think that was our last slide. Yeah. Any other questions, Nikhil, Abhinav?
No, there's no question on the chat right now.
Okay, all right. That's good. Then we are also more or less out of time. So great. This was a great discussion with everyone. I hope you all learned something, and I hope to hear back from some of the startups who have attended this session on their inputs on the on the points of discussion.